Wonderful. Well, welcome to World Arbitration Update from Warsaw. It is a pleasure to give you warm welcomes. My name is Jose Antonio Rivas. I am one of the co-founders of World Arbitration Update, and it has been for a long time an objective to launch World Arbitration Update from Eastern Europe, and this year we're able to do it for the first time, in great part thanks to Jadranka Jacoby, and in great part also thanks to Sirsar Qureshi from PricewaterhouseCoopers. So thank you very much to both. I am a practicing attorney here in Washington, D.C. I am also a founding partner of Strategy LLP, which is a boutique law firm doing investor state arbitration, commercial arbitration, as well as public international law. And I also teach at Georgetown what I practice, which is investment arbitration and public international law. It is wonderful to have you all here. And this panel will be, it is one of our practical series. Yesterday, we had in Washington, D.C., a workshop on how to draft memorials. And this panel is on effective cross-examination of expert witnesses. It is, I believe, the first time that we focus on expert witnesses, and we have an incredible number of experts, both expert individuals who have been expert witnesses, as well as counsel who have a lot of experience acting as counsel and cross-examining expert witnesses. So, but before the panelists are introduced, I would like to introduce Jacob Banowetz, who is a senior counsel at SK&S, and you will forgive me, I don't want to misspell the names in Polish, and he works there in the litigation department since 2011. In 2019, he completed an internship at Hanotio and Vandenberg, an arbitration and litigation boutique in Brussels. Jacob represents clients before both domestic and international arbitration tribunals, as well as state courts, in particular in complex damages proceedings, as well as in post-M&A and corporate disputes. He has been recognized as a rising star in the field of commercial arbitration by Expert Guide's Rising Stars, as well as a key lawyer in dispute resolution by Legal 500. So Jacob will be introducing our speakers, but before he does that, I would like to introduce briefly Drenka Jacoby, who has been instrumental in putting World Arbitration Update in Poland. She is a civil law and common law trained international arbitration counsel. She has advised both states and investors in investment treaty and commercial arbitrations, including in exit cases. She has previously practiced in Croatia, Italy, and Belgium, and Brussels as part of the legal service of the European Commission. And currently, she serves as co-chair of the Young Croatian Arbitration Practitioners and is the immediate past co-chair of the International Dispute Resolution Committee of the New York State Bar Association. Jadranka has been recognized as one to watch for dispute resolutions by best lawyers. She is a member of the World Arbitration Update Organizing Committee of our executive committee, and she is chairing this first edition of the event in Warsaw. Before we do this, I want to emphasize two objectives that we have in World Arbitration Update. One objective is to update the international community on issues of investment arbitration, public international law, and international commercial arbitration. And we do this by way of panels, which are recorded and put up in our library. So you will be a star in the recording, and many people should be able to access and learn from you. And two, the other objective is to decentralize international investment arbitration and international commercial arbitration, and public international law, decentralized international arbitration in general. And what we mean by this is that we know that there are incredible counsel experts in Poland, in Eastern Europe, and as well as in Africa, as well as in Latin America, as well as in Asia. And that's why we are doing the panels from those various places. And the centers of international arbitration are not necessarily only in Paris or in London or in New York or even in Washington, D.C. So we have to go beyond those centers and try to bring everyone to this platform so that people will know and watch you as well. With that, Drenka, you have the floor. Thank you.
Thank you very much, Jose Antonio. Now, I just want to add a couple of words and then give the floor to our wonderful panel here. Dear guests, good morning and welcome. Whether you're joining us in person here at PwC's office in Warsaw or tuning in remotely, we're delighted to have you with us. It is my distinct privilege to welcome you to the 4th edition of the World Arbitration Update, which is also, as Jose Antonio just mentioned, the first one to encompass Central and Eastern Europe. With the two main goals of the World Arbitration Update that Jose Antonio just mentioned, the conference each year brings together the international arbitration community across multiple jurisdictions to discuss timely issues of international arbitration and public international law. And so with that goal in mind, this year, the conference features over 20 events, which started last week with an event in China and continued throughout this week with events in India, the Middle East, the Americas, and now Central and Eastern Europe. None of this would be possible without the generous support of our wonderful hosts and sponsors. So on behalf of the executive team of WOW, I want to extend special thanks to our host, PwC, and to our sponsors, Kubaskos Galkowski and Baker Hostetler, for their invaluable support in helping us bring this conference to the beautiful city of Warsaw. Thank you so much. Now, today's event here in Warsaw will cover 3 main topics. We will kick off the program with the effective cross-examination of expert witnesses. We'll then move on to discuss the managing of a specialized international arbitration practice. And finally, we will close the program with a fascinating topic of the effects of global trends and geopolitics on energy disputes in the region. So with that, I warmly invite you to stay with us throughout the program. And once again, welcome to Warsaw. I would also like to briefly give a mic to Sirshar to just give a few words as our host.
Not much really to add except to welcome everyone to our offices. We're delighted actually to be the first edition in Central Eastern Europe in Warsaw, and we hope this will be one of many in Central Eastern Europe as well. So everyone welcome. Thank you.
I guess it's my turn now. Yeah. Okay. So, Jose Antonio, Drenka, thank you for this kind introduction. I would like to welcome everyone to the first panel, and thank you also for inviting me to moderate it. It's an honor to be here, these amazing professionals. I will introduce you shortly, but before I do so, I would just like to say a few words about the subject of the panel, which is the cross-examination of experts in international arbitration. This is a classic subject at various conferences, and it never goes out of fashion. I think rightly so, because the significance of cross-examination of experts in international arbitration cannot be overstated. It is much more important than in state court litigation, because if you are in a state court and you are doing your job well, and you do effective cross-examination, you probably end up with the opinion of another court-appointed expert. In international arbitration, this is much more significant, because especially if you represent the claimant or a respondent, sorry, and you manage to underestimate the credibility of claimant's expert, this means that you most likely will win the case on the quantum, or at least will convince the tribunal to base the judgment, the award, on your own expert's report. So there is a lot of win, and consequently there is also a lot to talk about. Today we have 5 panelists with us. They have different legal background from both common and continental law, and represent different professions. We have 4 counsel and 1 expert. I am sure that this diversity will make the panel more interesting and will make our observations and conclusions more valuable. As I heard, it is proven scientifically that diverse teams come together at better conclusions and are generally smarter. So, without further ado, immediately to my left sits Helena Szwandowa, associate at Squire Patton Boggs, based in Prague, Czech Republic. She focuses predominantly on investor state and commercial arbitration, but also advises clients in proceeding before the Czech courts. Her rich experience involves investment arbitrations, construction dispute, and arbitration proceedings against a supplier of industrial machinery. So I would imagine she definitely must have substantial experience in cross-examination of experts. Then we have Helena is a presenter of this panel, so she does not have any specific topic here, but she will provide a general overview of what we will be discussing. Then we have Mr. Sashi Dimitrov, partner at Baker Hostetler, based in Houston, Texas. He's a Chambers rank lawyer with vast experience in international arbitration. He is an adjunct professor at the University of Houston School of Law, where he teaches classes in international arbitration and international risk management in oil field services. He has also authored numerous publications in the same field and spoken during conferences. As I noted, there are many nice testimonials regarding his work, one of which is very much appropriate to cite today. So people say about Sashi that he's extremely dedicated to his clients, and his cross-examination skills are superb. So he is definitely the right guy to be with us here, and thank you for coming. Then to Sasha's left, we have Mr. Parvan P. Parvanov. Parvan is the head of International Arbitration Chambers in New York. He has a practice dedicated exclusively to international arbitration based out of New York. He is a US and Bulgarian trade lawyer, trying international arbitration cases as lead counsel, with particular focus on matters arising of Central and Eastern Europe. Parvan will say a few words regarding effective approach to cross-examination of expert witnesses, obviously in international arbitration. Then to Parvan's left, we have Julia Dyras from Warsaw. She is an advocate and counsel in the Dispute Resolution Department at the Warsaw office of CMS. Julia represents clients primarily in energy, infrastructure, technology, transportation, and construction sectors. So also the cases that I would assume involve expert witnesses. She has significant experience in post-M&A and shareholder disputes. He is recommended as a key lawyer in the area of dispute resolution by Legal 500. Importantly, Julia has also served as an arbitrator. So her experience with cross-examination seems to be diverse, and we are looking forward very much, Julia, to providing us with your insights from both sides of the table. Finally, Mr. Shirsha Qureshi, forensic partner at PwC, based in Prague. Full position is Dispute Advisory Center of Excellence leader and EMEA Forensic Services co-leader. Over 30 years of experience and testified as an expert in more than 40 cases. I received Shirsha's CV. It is so extensive that we probably could dedicate the whole panel to discussing his achievements. We are not going to do it, but just when we were preparing for this panel, Shirsha said, so my job during cross-examination is easy because I simply answer questions. So he's not only excellent, he's also very modest. We're looking forward to your insight as well. Okay, just a few organizational points. The whole panel is scheduled to take 1.5 hours. We started with slight delay, so I think we'll be ending about something before 12. We'll have 5 presentations. We'll start with that. All of them will take approximately 5 to 7 minutes. And after that, we'll start a discussion in which all of you also present here and present online are invited to participate. Without further ado, over to you, Helena.
Thank you, Jacob. Let me just share my presentation with everyone. Thank you, Jacob, for the very exhaustive introduction. I don't think I need to repeat that. Welcome to everyone here in Warsaw, as well as everyone joining us online. It is my pleasure to open this session by providing an introductory presentation on the topic of our panel, which is the effective cross-examination of expert witnesses. And this topic is obviously extremely complex, so I have no ambition in being exhaustive, but I will do my best to just provide the very basics, of which our further panelists will be able to follow. So the areas I want to focus on are the objectives of cross-examination, the specifics of different types of expert witnesses, the factors that should be considered when planning for cross-examination, and the areas of focus that are usually chosen by the counsel as the areas of attack against the expert report of the expert witness. So moving on to the objectives of cross-examination, of course, the overarching objective is for you to help your client win their case and use the cross-examination in order to achieve this objective. There are a few ways to do that. One way is to neutralize harmful evidence, for example, by impugning the credibility of a witness. Another way is to elicit useful evidence from the witness, for example, an admission that you can cite in your closing arguments or your post-hearing briefs. Another way is just to direct the tribunal's attention to the issues that you view are key to your case. And of course, any other means that advance your own case theory. Having that in mind, I will move on to the specifics of expert witnesses because the previous objectives are equally applicable to fact witnesses. So, and the expert witnesses, of course, do not testify on events that they were personally involved in, but provide expert opinions on specialized issues. And based on these issues, I have grouped the expert witnesses into 3 different categories. We have the evaluation experts. These are the professionals who are very well trained in defending their expert opinions in cross-examination and are probably the toughest opponents of every litigation or arbitration counsel. We're lucky enough to have one such expert among us, Sershar, so I will leave it to him to give us more detail on valuation experts. Then we have legal experts, and these can be also very experienced professionals if they are litigation lawyers. But in that case, they might be lacking in some credentials that would give them sort of more relevance to their report. So more often than not, the legal expert will be a professor or constitutional court judge or someone who has no experience in cross-examinations and will require a lot more preparation in terms of the technique than a valuation expert. And then we have technical experts. These are just a very broad category. They can include engineers, but also different industry specialists. And there's one additional objective that I want to mention that is applicable to expert witnesses and their cross-examination. And that is related to the fact that sometimes the expert reports are very technical and as such very much outside of the tribunal's expertise and also outside of the tribunal's comfort zone. So it is the counsel's role to help the tribunal decipher the expert report and to persuade the tribunal not only to take the conclusions of the expert at face value, but to actually critically scrutinize the report and not be afraid to go into detail. So in that sense, we act as kind of translators to the tribunal. Now, moving on to important factors that should be considered. We will hear a lot more on the effectiveness of cross-examination from Parvan later on. But I just want to mention some things that I view are the most important to have in mind. I've already spoken about the importance of being aware of the expert's experience and background, but it is equally important to be aware of who your arbitrators are. They may be from different countries, and they may be from different legal tradition and have different expectations on what a cross-examination should look like. So for example, some arbitrators will tolerate more aggressive style of cross-examination and will tolerate more leading questions. Of course, the arbitrator's jurisdiction may give you some guidance on that issue, but it's also very important to consult your colleagues and ask them about the arbitrator's preferences. Other important factors are whether the expert witness speaks the language of the arbitration or if they will need simultaneous interpretation, which gives us an additional layer of complexity because there's a delay that gives the witness time to think about the answer. But the interpretation can also cause a lot of miscommunication, and it is that much more important to be very attentive to the interpreter. And another layer of complexity, is added if the hearing is virtual, and we will hear about that from Julia later on. And then it's also important to keep in mind that every word you say is being usually transcribed. So the questions need to be formulated and every word needs to be chosen wisely. And lastly, of course, it's important to keep in mind the applicable rules and orders of the tribunal. The arbitration rules are quite minimalistic when it comes to cross-examination and give a lot of discretion to the tribunal. So it is important to always check the procedural orders and see if the tribunal has applied some sort of limitations. For example, the tribunal may limit the scope of the cross-examination only to the issues that are discussed in the report, and you may not cross that boundary. In the interest of time, I think I will skip the next slide, which just gives an example of different rules that may be applicable. And I will instead move to the areas that are usually focused on by the cross-examining counsel. The first three areas, independence, qualifications, and consistency, will crystallize from a detailed background research of the expert witness. In terms of independence, we should ask, are the disclosures made by the expert true, and are they complete? In terms of qualifications, we should ask, does the expert have the credentials and experience important for the issue they're opining on? In terms of consistency, has the expert previously expressed conflicting views on the relevant issue, and that we can show the tribunal that they are actually not being completely honest, or at least force them to explain the change in their opinion. In terms of instructions, are they too broad? Are they too narrow? Are they even relevant for the outcome of the case? In terms of assumptions, Are the factual assumptions relied on by the expert complete? And are they correct, or can we contradict them by the evidence available on the record? In terms of methodology, is the methodology chosen by the expert correct? This is typically discussed, for example, when claimants apply the discounted cash flow valuation method. And even if the methodology is correct, did they apply it correctly? And the last category I've included is foul play. And what I mean by that is any sort of dishonesty displayed by the expert that we should drill into. An example from practice is that we had a valuation expert who provided a calculation spread over 900 different spreadsheets, interlinking the numbers, and it was really difficult to untangle that. But when we did that, we realized that the expert did not provide any sources for most of these numbers, and it seemed like they were just trying to hide that fact by just adding layers of numbers and complexity to it. So if you spot any sort of dishonesty, it's always important to drill into that and draw the tribunal's attention to that. Being mindful of time, I think that's all I have time for. So thank you for the attention.
Many thanks, Helena, for this thorough and valuable overview of the topic. I will now give the floor to Sasha, who will make a presentation on the different kinds of experts. Over to you.
Thank you. First, the technical difficulties. There we go. So because we've got a panel of people talking about the same general topic, there's going to be a little bit of overlap, but I think our different experience might be useful. So when I was first asked to speak about this topic, different, the question becomes, let's go to the beginning. What is different? What are different kinds of experts? But there's a lot of differences. Helena already talked about one difference, which is the difference in the subject matter, the substantive issues, the technical experts, the legal experts, the quantum experts. And the approach to these experts is very different. The one thing to keep in mind with experts is they're far more qualified than the lawyer cross-examining than many of them have PhDs. The technical experts tend to be those who talk about, for example, liability, the engineer. Did your equipment work properly? Did your refinery operate under the proper standards? Forensic accountant, where did the money go? Do you keep your financial records according to generally accepted accounting principles? And the problem is you can't really enter into a technical argument with one of these experts. That's really not your job. Your job is to be able to work with your expert to figure out what portions of their testimony can you poke a hole in? What part of their testimony are you able to weaken the credibility so that your expert's testimony becomes more credible? Legal experts, as Elena mentioned, tend to be judges, former judges. They tend to be professors. They've typically written books on the subject, and they're involved with their multi-jurisdictional questions of law. Now, we're all lawyers. We know the law. But on the other hand, my international arbitrations tend to be in countries where I'm not qualified to act. So what do you do when you're a Texas-based lawyer, but you've got an arbitration in Warsaw? I'm not a Polish lawyer. When I've got an arbitration in London, I'm not an English lawyer. And you've got an expert that talks about, for example, treaty applications or the applicable law in Switzerland and Colombia. They're going to present their views. They've probably written books. But the question really becomes, how credible is this? And is there any problem with the testimony? So one of the unique things about cross-examining legal experts is what did they present? Was it their testimony? Was it based on their books? What did they not present? They're often recognized experts in that exact legal field who've written books. Do they disagree? And first question is, do you recognize this expert as someone who's authoritative on this issue? Yes. Do you recognize this treatise as being authoritative on this issue? Let's talk about the legal principles they discover in. Notice they take a contrary position to yours. Did you consider that in your report? There are legal principles that you omitted. Why did you omit them? And would that make an effect if these exceptions actually were applicable to your question? As far as quantum experts, again, the difference here is it's a different kind of expert. They tend to take unreasonable positions, with all due respect to my friend at the end of the table. If it's a claimant's expert, every claim is worth gazillions of dollars. If it's a defense expert, they're all worthless. But what are the prerequisites? What are the assumptions these experts made? For example, if the assumptions, first of all, who gave them the assumptions? Was it counsel? And are they reasonable assumptions? If they use the model that Elena alluded to, for example, the valuation model, discounted cash flow model, each of these models requires assumptions. And if you change the assumptions, you change the result. So for example, if you ask the expert to assume, without accepting as true, but it's a hypothetical, assume that we change your valuation model by putting in a different parameter. Would you agree with me that all of a sudden your gazillion-dollar valuation drops down to $1 million? Similarly with the expert. You don't have to prove it to that expert. You simply establish the fact that he agrees with you. If you change the parameters, everything changes. Now, again, we talk about different kinds of experts, and these are the ones we've discussed. But another difference in experts is who appointed the expert. Was it tribunal or was it the lawyers? Why would a tribunal appoint an expert? Several reasons. Many times the parties' experts, frankly, every time the parties' experts disagree on some of their fundamental conclusions. And if it can't be reconciled, the tribunal may appoint an expert to do an independent analysis. There's a perceived fairness if the tribunal nominates the expert. But where does this right come from? And the right really comes from the rules that you choose to apply. I always find it interesting when we have an arbitration that has both civil lawyers and common law lawyers. The IBA has established a set of rules for taking evidence, but they tend to be very common law based. They tend to be based on the English system, the American system. And many of the arbitrations don't take place in England. They don't take place in the US. And the practitioners tend to have a very different procedure they're used to, the civil law tradition. So the IBA came up with an alternative set of rules, the Prague rules. And the Prague rules tend to identify and allow the parties to use rules that are very much based on civil law procedures. So under the Prague rules, the tribunal has primary responsibility for not appointing experts and managing their testimonies. Very unlike the common law system where it's counsel's responsibility to put on an expert. It allows the parties, generally these types of tribunals, when they elect their own expert, they allow the parties to select their own experts, and those three sets of experts will talk and present evidence. What's the advantage? What's the advantage if the tribunal presents an expert? Well, first of all, it's greater capacity for the expert to be impartial. He doesn't work for either party, so presumably that expert's testimony is going to be impartial. It streamlines the presentation of the evidence. Presumably, this expert's going to use only one analytical approach. And everybody gets the shot at the exact same expert based on the same report. What are the disadvantages? Well, first of all, it limits the party's ability to present their case autonomously and persuasively. That presents the party's ability to oversee the expert's testimony. If I have an expert, we've worked on his presentation, we've worked on his conclusions, we've worked on the presumptions he's made, and we've also worked on the best way to present that evidence. I don't want the tribunal's expert to decide what is important to my case and the most persuasive way to present that evidence. Whereas if the tribunal has appointed that expert, I don't control how that evidence comes forward. I don't control what's emphasized and what's not emphasized. And I think the most important difference when you have a tribunal appointed expert is without an opposing expert, their testimony has much less rigorous review. There's no one challenging them. There's no one questioning their review. Therefore, it's my opinion that an expert that's been appointed by the tribunal, their testimony is less reliable because it has been put through the rigor of cross-examination and the testing of another expert. I think the standard thinking is that arbitrators recognize the weakness of a tribunal appointed expert is generally not a favored way to go. And finally, what's the difference in jurisdictions? We talked about common law versus civil law. And coming from the United States, my impression is there's a lot of fear of the US system. For example, how do we try cases in our state where it's not an arbitration, but we have juries? What's a jury? There are 12 people you got off the street. Well, not off the street, but these are people who are registered to vote. That is the only prerequisite for someone to sit on a jury. So the people that are sitting on the jury are a librarian, a janitor, a fashion designer, an auto mechanic. They have no legal training. They have no background in the facts. But the idea is we're going to present our case to a bunch of reasonable people and let them use their judgment about what happened. As a result, when we present our cases to juries, including the experts, we tend to be flamboyant. We tend to want to persuade a common person without this background. And we will ask questions like, for example, when cross-examining an expert, isn't it true that you didn't consider this fact? In fact, you affirmatively omitted it. And that's not correct, is it? And when you say something that's not correct, that's a lie, isn't it? So you just lied to this jury. In civil law jurisdictions, that's an outrageous set of questions. In fact, in my understanding, is most civil law jurisdictions, generally it's the judge that asks questions. And certainly while counsel may have the ability to question witnesses, really the judge has a lot of authority on how the questioning is done. There's no jury, there are no lay people. So the question becomes, what happens when you're cross-examining a witness, an expert witness, with arbitrators who are from the United States and who are used to jury trials in their general practice, versus when you have arbitrators that are from civil law jurisdictions? I will give you a recent example from a case arbitration we just tried. My opposing counsel was Israeli, and I thought American lawyers were aggressive. I will tell you, the Israeli tradition is incredible. The level of aggressive questioning was something I'd never seen before, but it's part of their legal system. We had one arbitrator appointed by my client who's American. We had an arbitrator appointed by them who's Israeli, and the presiding arbitrator was Australian. So my opposing counsel, when questioning my expert, would ask questions like, isn't it true that the only things you considered were what your lawyers gave them, but you still recognize that your client's product was defective? Now, covered in shame, you refuse to tell the truth. And I object. So like, what kind of a question is that? You know, he doesn't talk about facts. He doesn't talk about opinions. He talks about the subjective intent of the expert. And it has absolutely nothing to do with the facts of this case. And after having those sorts of questions over and over and over, the American arbitrator actually scolded the lawyer asking those type of aggressive questions, saying, you need to stick to the facts. You're being unprofessional and you're being unduly aggressive. The Israeli arbitrator said, what's the problem? I don't understand. And with the president of the tribunal, when faced with the objections that I was making, essentially took the middle road, which is, look, could you please ask a factually based question that's relevant to the issues and relevant to the opinions of this expert? Please rephrase your question. So I believe that kind of questioning lost my arbitrator. In other words, it lost the credibility of the lawyer asking it. I believe my different style may have lost the Israeli arbitrator, but then you've got the presiding arbitrator who's more neutral and from a more neutral system. But I will tell you that depending upon the jurisdictional background of the arbitrators, the method of questioning makes a difference. And often it's difficult to pivot to the extent necessary unless you've done your work ahead of time. Thank you.
Thank you, Mr. Dimitrov. This was fascinating, and as you said, there's going to be a little bit of overlap in the topics that we talk about. I will take over you and try to get a little bit more specific about the best practices in conducting an effective cross-examination. If you just give me a second, I'll try to share my screen. I tried to boil this down to only 2 slides, although it is a very vast topic that can take hours of discussion. I'll be happy to. I think that we can have some interesting questions taken after the presentations are finished. Before, on the second slide, I have actually outlined some of the best practices that I think work best in conducting an effective. Enlarge it. Okay. Is that better? A little more? Is that good? All right. But before I go to the actual specific best practices that I think should be mentioned here, it's probably best to get a lay of the land first. As was mentioned earlier, one of the things that you see more and more often in international arbitration is that you have these professional testifying experts who are excellent at commanding the record and their testimony, and there's no real admissibility bar to testifying and putting a report on the record, which kind of provides this over-inclusiveness in the presentation of experts and the admissibility of experts generally. And on the other hand, you have the issue of the diminished methods for control of what the experts say and how they say it. Normally in Mr. Dimitrov touched on that, in US litigation, you would have an actual deposition taken of the experts before that, so you're going to be able to run their position against their expert reports during cross-examination, which you don't have available in international arbitration generally, which takes away a lot of the ability to control what the expert says. And as I already alluded to earlier, they are pretty good at presenting. The other issue with the diminished ability to control is the fact that most arbitrators, and that I haven't seen in practice much difference between those trained, the chairs, the presiding arbitrators trained in the civil or the common law tradition, they just tend to allow everything. They just want to hear what the expert has to say. And with the lack of extensive discovery, you're basically left, the cross-examining counsel is left with very little they can do to control, particularly sophisticated experts who are not just trained how to do it, but they're actually extensively prepped with counsel before the cross-examinations take place. So the question then arises: what do you do in this situation? How do you actually regain control of what the expert is going to say? And my practice, and I think what I'm observing is pretty much exclusively these days, the method is to anchor in the documents. Obviously, and as Mr. Dimitrov already alluded to, you need to do your research on the expert, particularly prior writings of the same expert or other testimonies. It's not very easy to do that, particularly with experts who come from jurisdictions where there is no publicly available information as much as in other jurisdictions. But it is very important to do that before the cross-examination. So basically, once you've done your research and you know your record, the cross-examination normally proceeds by way of chronologically running documents through the experts in order to pin them to the particular whatever the document says, so that they cannot have much. They wouldn't have enough capability to use their otherwise expertly control of their reports to provide direct testimony and provide their positions. I think with one of the things that I've seen that is very effective and very important to do is to not stick to your script, which you need to gauge the question in the lines of questions you do based on how it's going on. I think intuition is very important in these situations, and in order to stick to to anchoring in the documents, you basically need to know the record very well in terms of what the documents say. I very often find that an expert would pivot on a position as they go along because they feel like it's not going their way, and you know that this particular position that they're trying to pivot on is contradicted by a particular document that's in the record, but it was not part of your original script. And that's preparation is key in these situations. In terms of form, I find that these days counsel and tribunal presiding arbitrators have kind of come to the point where they've reconciled the common law and the civil law tradition, and the example with the Israeli approach is very interesting to hear. I had a very similar experience. They are very aggressive, even aggressive even on the U.S. standards. But those are, I think, are kind of rare instances in which you will see these kinds of how should I put it, non-internationalized kind of approaches. Normally what I see now these days is that leading questions are very much accepted by most presiding arbitrators, with the caveat that they should be in the kind of the milder form. And what I think is the most effective form is to try to provide the questions in a way that they actually give you the answer. So you had the leading part of the question, but also it needs to include the answer. And then whatever the expert says, you will have provided to the tribunal the position that is favorable to your position and to your client. Now, with that in mind, I move to the second slide, which provides a list of what I think are the most effective practices and approaches to conducting the cross-examination. And this may not be very visible, but you will see that there's a difference between the first five are bolded or are different colored than the last five, and the difference is that the first five, I think, are apply universally to regardless of who the expert is and what kind of expert it is. They just work across the board. And the first one, and Mr. Dimitrov alluded to that, it's and I can't agree more. Very often I see counsel entering into debates with the experts about complex issues. If you find yourself doing that, you already lost, because the tribunal is going to always think that the expert probably knows better what they're talking about. And normally the way I would get out of a situation like this is I would just say, well, let's leave this to the expert later. And when I say the expert, I mean the expert on the expert for the client that I represent. And the other way to get out of this that I use is probably to just leave it for summation or for argument. In the end of the day, and this was, and Helena also alluded to this earlier, the goal that you want to achieve in these cross-examinations is to convince the tribunal that the opposing expert is not credible, that they shouldn't trust their opinion. Tribunals are rarely thinking about, if ever, who is actually right. Is this formula applicable here? Is this the right statement of the law? They just want to know who to trust. So you're kind of working with a lower standard here. You don't need to show to them that the particular expert testimony is really correct, is the state of the art of or the state of the law of whatever country, and so on and so forth. The second really good practice, and this is extremely effective if it's done properly, and it goes to preparation a lot. But you need to focus on selectivity, and Mr. Dimitrov alluded to that earlier. If I can just go into a little bit more nuance on this, because again, it's very important. Selectivity, and you will be surprised, is often within the very document that the expert is citing, and particularly if it's a longer. I've seen legal experts citing 2 chapters of books that are like long chapters, and if you continue reading down the chapter, you'll see that the author actually caveated a lot of the things that were said in the portion that was cited by the expert for a certain proposition. So it's very important to dig in for selectivity, including in the specific documents that a particular expert has cited. Not just the broader aspect of this, of saying, look, did you consider the fact that so and so professor has actually opined otherwise? As a corollary to that, it is very important to emphasize on what the expert did not do, and that's not just a good impeachment method, but also something that highlights something that allows you not to provide the floor to the expert to provide direct testimony, because once they start speaking and they put their positions against the tribunal and they can hear them, they actually can be very effective. Once you start looking at what the expert did not do, that's kind of taking away the focus from the actual direct testimony, which was obviously very carefully crafted. The big one, of course, contradictions. If you can find them, they are really effective. One tip from me on this is I've seen counsel go too quickly into the contradiction, don't do the setup properly. Contradictions are very effective, but they need to be you need to take the witness there in an effective way. And when you do it, you need to be careful not to allow too much repetition of the position of the expert before you lead them to the contradiction, because sometimes it just gets buried. Once you expose the contradiction, it gets buried in the direct testimony that was provided before that. Pivoting is very strong when it's based on a mistake, and it normally, I mean, at least I haven't been lucky enough to get those experts. They would pivot, but they would have a good explanation why they pivoted. So it's you got to use your discretion in using pivoting for impeachment. Authorship. This is a very interesting one. Very often you would see, and particularly with experts that are not professional testifying experts, you would see that with one-off experts who are experts in their field, but they were just commissioned for that particular case. They would have others work on the report, and if you can actually show to the tribunal that they didn't have much involvement in the writing of the original parts of the report, they've only looked at it after. This actually has worked miracles for me in some cases, but again, it has to be used with discretion. Sometimes it's just the case that, and it's very well accepted by the top arbitrators out there that people get help, and it's perfectly okay. So it really depends on you need to do it with discretion on a case-by-case basis. I move on quickly to the list of the less bolded best practices. Those don't work across the board, I feel. The credibility of impeaching on credibility as expert in the field is normally a very big one when it comes to admissibility. If you have a system where there's admissibility, like in the US, I'm personally am a big proponent. I was very taken aback the first time I actually had an expert who was clearly testifying to something that was, one, irrelevant, to two, the person was not an expert in that particular field. They were just an expert broadly in the field, but that doesn't make you an expert. And they were just polluting the record with hundreds of pages of good research, well done research. But the tribunals tend to be unfazed. They just, because they're worried, and Mr. Dimitrov mentioned that earlier, if they're just worried about due process challenges. So, and you can see it, you can see they're convinced that this person is just not an expert in that field, but they just let them speak. The one time that I think this works as effectively as an impeachment method is with technical experts, because there it's very clear who between the experts has done the research and has done the work, the actual expert work on a particular method that's used for the for whatever is the question that's in issue in the case. It's less effective, very ineffective with legal experts. Tribunals just tend to accept that if you have a PhD in some topic on that law, you're an expert in law. You can testify to complex bankruptcy issues, for example. One of the effective questions that you can ask there, if you want to impeach on expert qualifications, is have you ever done any litigations in court, sir? And normally the not real expert will be, well, no, but I've written an article. Well, what's written in the books is not really what really happens in court. The other one of the things that works with legal experts that I found very effective is to expose them as hidden advocates, and that happens very often. The parties would bring a legal expert who actually works with the fact that the law as a fact is a very complex fact, right? And they're very well trained lawyers, so they sometimes try to tweak what the law actually is, acting and using their skills as advocates. They forget that one of the important things that the tribunals look for is objectivity in an expert. So if you're impeaching a legal expert, probably not as effective to go for their expert qualifications, but to go to objectivity. And Mr. Dimitrov alluded to that earlier. Damages experts are most vulnerable to attack on assumptions. I think with this, I'm going to conclude my presentation. I hope I managed to stay within the allotted time. Thank you.
Proceed on this slide.
Thank you.
Thank you very much, Pavan. If I could just ask you to stop sharing your screen, and I will share my presentation. Is it visible? Thank you very much, and I would like to start off by thanking the organisers of the World Arbitration Update for the opportunity to appear before our wonderful audience today, both in person as well as online, together with my esteemed co-panelists. I believe that the topic of my presentation today concerning the cross-examination of experts in a virtual hearing is very fitting also for the format of this conference, given that we have the majority of participants of this conference online. And by way of a short background, as you all very well know, the COVID-19 pandemic brought about a proliferation of the use of online hearings and introduced the legal profession essentially to be the ability of carrying out an international arbitration entirely or predominantly online. And while hopefully the COVID-19 pandemic is behind us, it seems that virtual hearings may be here to stay and be used very frequently in different types of international arbitration proceedings. And the use of virtual hearings is not particularly surprising, given the fact that they carry with them multiple benefits. The first and primary benefit being the savings of cost and time connected to a in-person hearing and organizing a venue and travel to the venue. They are also more convenient and efficient, especially when we are dealing with a panel of 3 arbitrators who are very busy and are usually sitting on a variety of different parallel arbitrations. And it is much more easier to find a convenient and expeditious hearing date when we are dealing with virtual hearings. There are also multiple social benefits to virtual hearings, those being in particular the inclusivity. Virtual hearings allow for the easier participation of particularly persons with disabilities or persons who are located in remote locations, and they are more environmentally friendly, leaving a lesser carbon footprint. At the same time, from my personal experience and talking to other counsel, and much has also been written on this topic, counsel are very hesitant, if not entirely opposed to the concept of carrying out an evidentiary hearing online, especially a hearing that involves the cross-examination of witnesses. And there are several concerns that have been voiced among counsel during my own reconnaissance of the subject and from what can be read. The primary concern that is the possibility of controlling the cross-examination and controlling the expert witness. During a virtual hearing, we are deprived of the human connection that we have with a person who's sitting across from us in a room, and thus there is a concern about the deprivation of certain in-person and non-verbal cues that can be had when we are experiencing the physical proximity of the person that we are examining. And this also leads to a concern that this doesn't just deprive counsel of some control over the expert, but also of the tribunal's ability to be able to assess the credibility of the expert witness. Also, the tribunal, not only counsel, but the tribunal is deprived of these non-verbal cues and thus may not be able to adequately decide whether or not a witness is credible. This is exacerbated by the fact that, as we all know and has been well written about and documented, virtual hearings are much more exhaustive and are much more exhausting to all participants and carry with them a greater risk of distraction when we are forced to sit over long periods of time in front of the screen monitor. And there have also been raised concerns as to the integrity of the proceedings, in particular concerns when we have an expert who is in a virtual setting, that there may be concealed channels of communication between the expert and counsel, or between the expert and third parties who may, for example, be present in the room during the cross-examination. That being said, I think it is worthwhile for me to state my position on this topic. And I do believe that while there are significant challenges and particular challenges to carrying out a virtual evidentiary hearing which involves cross-examination, I do not believe, of course not in all cases, but that in many cases a virtual cross-examination is either superior or inferior to an in-person hearing. It is simply different and requires well, not a slight, but a massive readjustment and relearning of certain counsel techniques to be able to be carried out effectively, but when done so, can be just as effective as an in-person hearing. And I would like to share some of my thoughts on issues that can allow for the proper preparation and carrying out of the cross-examination in a virtual setting. The first one is a technical and logistical preparation. And by technical preparation ahead of the virtual hearing, I don't just mean a thorough preparation, as has already been mentioned by Parvon earlier, of the facts of the case and of the substance of the case and what we want to be asking the expert, but preparation of the ground rules of the virtual hearing, so as to be able to give ourselves the comfort that the integrity of the proceedings is being protected and that we are able to retain control over the expert, both when we are carrying out a cross-examination and when our own expert is being cross-examined. And these ground rules are usually set out in a virtual hearing protocol or a procedural order. Many arbitral institutions, including the ICC, have published their proposals for a model virtual hearing procedural order, and such procedural orders can regulate in a very granular manner any number of issues, ranging from the placing of the cameras, if we have a expert who's being questioned in a remote room, so that we can see the entire room and prevent from any undue influence throughout the cross-examination, through to a regulation on how to submit objections throughout the cross-examination, so as to prevent counsel and particularly the counsel and the arbitral tribunal to be speaking over one another. The second point that I would like to mention is that a virtual cross-examination, as I said, requires a rethinking also of the styles of cross-examination and the questioning techniques that are used. Sasha earlier referred to a very aggressive style of cross-examination, which I think does not necessarily carry across well in a virtual setting. And when we are participating in a virtual hearing, we react differently to especially audio cues, and which I believe are stronger during a virtual hearing, and a very aggressive or confrontational style of asking questions does not often and may not leave a good impression on the arbitral tribunal. That being said, I have seen and also experienced that engaging in a perhaps more, might I call it, conversational style of cross-examination, which is easier to do in a virtual setting, also can bring about very good results. An expert, and perhaps Sasha will be able to comment on that later, an expert who perhaps may be feeling a little overly comfortable during a virtual cross-examination may be found off guard when properly questioned in a more conversational style. Of course, these considerations also have to be discussed and taken into account when talking to our own expert. The expert has to be aware of the rules that we have established for the virtual hearing. In my experience, I've seen a hearing in which a cross-examination went slightly awry due to the fact that the parties had agreed on a manner of submitting objections throughout the cross-examination through a visual cue, whereas the expert was not looking at the screen when giving his testimony, and which caused him to begin answering questions which had been objected to by counsel, then forcing counsel to basically shout into the camera for the testimony to be stopped. This is something that could have easily been prevented if perhaps the expert had been more intensely coached on the ground rules of the virtual hearing. And the last issue that I wanted to touch upon is the presentation of the hearing bundle. As we all know, the cross-examination of expert witnesses is usually very document heavy. This is something that was also mentioned by Pavan earlier. And from my experience, when using available and very mature right now software and technology for the presentation of the expert bundle in an electronic setting, it seems that very often it is much easier to obtain beneficial results in the cross-examination when we are able to guide the expert very quickly and very efficiently through particular documents, highlighting sections, making them more visible on the screen, taking out excerpts of the document. This can have a very profound impact on the tribunal who is looking at the screen throughout the cross-examination, and can lead to in my experience, incredibly impactful and beneficial results for the cross-examination. So to sum up my presentation, and I am cognizant of time, while I believe that every case has, of course, its distinct features, and every case has to be decided based on those features, a virtual hearing does not have to be fundamentally different in its substance and in its possibilities to an in-person hearing. It simply requires a readjustment to a different setting. Thank you. I'm turning you off, I think.
Let me just. Okay, sorry, I just can't do two things at once here. Not working?
Yes, you see it here. Click play. Presentation.
Coming up in presentation mode. A bit better. Lovely. All right, well, sorry about that. I wasted Jacob at least a couple of minutes messing around with the IT, but I will try and be efficient and try and catch up a little bit of time. I know we'll get to questions.
It's 11:30 and we still need some time for discussion, but I'm not rushing you. Take your time.
And it's quite usual, actually, for the quantum expert to be at the end of the hearing. And it's fairly usual for there to be some rush. Now, the rush is usually not on me. It's sort of panic from counsel about trying to get the questions in on time. And it's usually a squeeze. So that's usually a luxury for me. But this time the shoe's on the other foot, I suspect. Well,
I still have some questions for you.
Okay, well, I better take my time then. So look, first of all, I'd like to sort of first take my hat off to lawyers who do cross-examination at all. I choose to be in this field. I'm a chartered accountant. I did exams and I knowingly went into it. Counsel are lawyers, tend to be, and they wanted to go into the law, and that's what they enjoy doing. And now they have to go and cross-examine technical experts on all sorts of nitty-gritty evaluations. So first of all, well done. I can imagine it's very nerve-wracking, very difficult. And I think it's all about prepare. But I think at the end of the day, you also have to do it. And then when you do it, I've seen it with a lot of cross-examination. I think, some are very good, some are very superficial, some are very, quick, very, some are very on time pressure. And I think you just need to prepare for the unexpected a lot of the time. So first of all, well done to all lawyers who take it up. Now, sometimes I don't know if you're getting the short straw or what it is within the team, but certainly it doesn't always start the cross-examination on the day of the hearing or just before the hearing. It starts in the selection of the expert, which happens quite a bit before. And I'm not going to go back to all the process up to it, but it is important to understand how you want that hearing to go, how you want your case to be presented, what types of expert do you want in terms from a quantum perspective. Do you want an industry expert? Do you want an accounting expert? Do you want an evaluation expert? Do you think a joint expert will work in this specific case in terms of having both together? And the experience of it. So all the questions that are coming up and were discussed by my fellow panelists needs to be thought about quite a while ago when selecting the expert in the first place. Okay, so time moves on, you selected your expert, you move on, and then you're planning your cross. The hearing's coming up, there's tight pressures, lots of things going on within the team, and you really need to work out, okay, what am I going to ask, what areas to focus on? And maybe I'll just flip through this in terms of I'm coming at this, and again, I don't want to repeat things that were said. I'm coming at it and looking at it from an expert's perspective. As I said before, I'm just the one answering the questions. Yeah. So in many respects, it's easy. In some respects, it's maybe less easy. So I think maybe, and echoing some of the points made, I think very much counsel need to prepare, talk to the expert, and understand what the weaknesses of the other side's case and really understand that. Now, they should have done that during the course of the preparation of the expert reports, but really how we're getting to the nub in terms of what actually needs to be asked. So certainly put it around a few core areas, I think principles, and keep it simple to understand. It's not always about trying to undermine the expert, but I think every counsel is different in terms of what they're trying to achieve, what they're trying to do. But I think certainly make sure in every case, I think it's about understanding, is the tribunal following? Is the chair following? Does the chair understand what you're trying to get from the question? The reason is because the only person you're trying to convince in that room is the president of the tribunal, and you need to be trying effective with them. So, not like feeling you get to a line of questioning and you think, so what? What was the point? Where are you getting at? So I think it's important to make sure the tribunal is following, and certainly as an expert, I'm told to look at the tribunal, look at the chair, understand really, are they following, are they not following my answers to the questions? Counsel's job is to make sure they're following, they're on the right page, which can all happen very quickly. You have documents flying everywhere, you're trying to bring the tribunal to the right page, and it can be a bit messy and complicated. Again, it's about preparation and making sure you're almost prepared for the unexpected in terms of what may happen. I see counsel do things in different ways, and certainly having a good script is a good starting point, but be prepared to go off script. I think the point's already been made as well there. I'm not going to go through all of this. I was just laughing to myself, talking about styles of cross-examination. It was mentioned about Israeli counsel. I think probably the toughest cross-examination I've had is with Israeli counsel. So I agree, I concur with my fellow panelists in terms of the fact of styles. I think I've seen very conversational styles. I've seen aggressive styles. Say, for example, it's a barrister. I think they get paid to be aggressive, I suspect. And I think sometimes I'm wondering, are they doing it for the tribunal to be effective? Again, question of what is effective with a tribunal. Are they trying to show their client who may be in the room, like, well, beating up that expert, so, that's all right, that will justify a little bit more extra fees. There's a lot of things going on. There's a psychology behind all this. So, and I can't pretend to understand everything that's going on, and why. All I can do is answer the questions in front of me in the way I can do. I think it was said, one thing that as an expert, if I get compounded questions or complicated questions, it's really genuinely hard for me to follow what's being asked. I'm trying to ask now. Some people say, oh, you're wasting time. You're trying to, well, it's not the case. It's like, really, I need to be led there. I need to be understanding what is the question. And I think, therefore, asking simple questions and taking the expert there carefully and the tribunal hand in hand, I think there's two factors to it is important. Listen to what the expert is answering. It's so easy to miss something the expert says that you could latch onto, because you're following a script and you're expecting, is this right, Mr. Qureshi? Yes. Is this right, Mr. Qureshi? Yes. Is it right? And then I'll start talking at some point. But listen to really what the expert is saying, because I think they may give you some nuggets that you can follow up on. Naturally, counsel should ask questions of which they pretty much know the answer to the question that's coming back. I mean, that's always taken for granted. The other thing, though, just in the setup, and I think every counsel is different, and maybe this comes back to the background. Do you have someone from the experts team to communicate with you during the cross? They can be sitting there and answering, so I won't do that. As an expert, I'm sitting right at the back of the room, nowhere near all of this going on. But maybe they'll want someone from the team to be closer. Now, that can be distracting for counsel. Sometimes it may be helpful. And again, this is just a tactic and working out, are you missing an obvious question or question to ask and follow-up question to ask? But again, counsel is different, and I think it's sort of working out what may work. I was just reflecting on what Helena said around sort of presentations and PowerPoints. At the hearing, it's fairly normal now. I mean, whichever type of tribunal you have, whatever counsel you have, direct is a presentation. It's a chance for me to speak for whatever time, 30 minutes, 1 hour. And it's amazing how much time you spent on PowerPoint skills and animations, and it's got to be visual and it's got to be easy. And I think therefore presentation is quite important at that point. But it's amazing how it's very much part and parcel of how things happen. Cross-examination is fairly standard. If it is classic cross-examination, that's easy. But as I said, for quantum experts, it's usually at the end of the week, or end of 2 weeks, or end of 3 weeks. Tribunal's tired, counsel's tired, and usually it never runs to schedule. It's always squeezed for time, I notice, and again, I'm just watching it. On virtual hearings, I find it very difficult because you can't really engage with the tribunal, I find, as an expert, and so therefore it's difficult to really understand. Now, I heard Julia's point, and I think that's right. You know, I think it's not quite the same, but I think I'm still seeing virtual hearings, and I have one virtual hearing going on right now, in fact. So it is happening, and I think it will be used in certain circumstances, and it will be used. Obviously, there's a matter about efficiency against effectiveness. Now, that's a debate we can have together. And I know we may have a question later on around hot tubbing. I think I'll say that I know counsel hate it. They want control, and they want to control the expert. And as soon as you give it to hot tubbing, and every hot tubbing I've been in, which is not very often, has been a bit different. And very much it's usually, for me, effective when the tribunal's running it. If they're answering the questions, which means the counsel will hate it, absolutely. Let me just run through here. So maybe I'll so that's a little bit about the process, I suppose, and what I've heard from my colleagues as well here. But maybe let's talk about how counsel can be effective with the experts. I think I would always say early engagement is important. Understanding the approach, as I said, this is the planning. This is way before to understand how whether your expert needs to understand, the expert on the other side, work with the expert to understand where the gaps are, etc. So I'll cover these points. And I think it was already said about genuine differences for quantum experts. There are only a few areas, really. I mean, some of them are around fact pattern and instructions or assumptions that were given by counsel. I mean, and they're legal points. Valuation date is a legal point. As much as then there's a hoo-ha about whether you use hindsight or don't use hindsight, it's a discussion. And again, it's a legal point. But therefore, that's an instruction given. But I think what's important, if you want to be as an expert truly helpful and counsel to instruct it as such, is to make sure that the alternative scenario is given as well to the tribunal. So you have your say, okay, counsel has told me assume this is the valuation date, but why not assume the other valuation date as well? Or does it change your opinion? How does it change your opinion? That's genuinely effective will be helpful to the tribunal to understand that. So we have a view in play. The genuine differences between experts to focus upon, and all this around, is it a reasonable instruction? It may be legal, but there can be instructions given that you can challenge the expert on about whether that's a reasonable instruction. Genuine differences, methodology, discount rates, cash flow. Every tribunal I've been in front of, they really understand about DCF, they really understand discount rates, they understand methodology, they know their stuff. So ultimately, I'm looking at the tribunals and you can see in their eyes, they know what they're going to do. Now, the question for me is whether at the end of the day, their award actually puts some logic behind it as well. But I do notice that they do know their stuff, and I think counsel need to understand that. But you do need to ask the questions, you do need to challenge the expert, you need to make sure that what are the points you want to make there. Keep on jumping around for some reason. Maybe, Jacob, I will stop there and just put it back to you, because I know we're keen to get some questions in.
Yeah. Thank you very much, dear panelists, for your valuable presentation and insight into the topic, which I really much appreciate. And I am, of course, keen to ask you many questions. But since we have also audience here, I see many renowned practitioners, also arbitrators. I think that out of courtesy, I should first give the floor to you and ask you if you have any questions to our panelists. I'm sure you will have.
My My name is Piotr Nowaczyk. I am a full-time arbitrator with an experience of maybe 500 cases, many of them with expert witnesses. My question I would like to ask you is, how do you like hot tubbing? To be more precise, hot tubbing of the experts.
Love it and hate it. The purpose of hot tubbing is to see if you can get the experts to agree on some issues and maybe streamline the process. I think it's a myth that experts are neutral advocates, neutrals. They're not neutrals. I wouldn't hire someone if they didn't agree with my position or certainly would give the conclusions that my client advocates. Now, they're not going to lie, but they're going to, the purpose of their testimony is to advance our position. The problem with hot tubbing is that the experts have their positions already. They have their reports, and you're essentially asking them to concede points that the other expert has given, and it's pointless. They're not going to. The only thing that it's helpful for is to reduce the issues for the experts to talk about, particularly if it's a complicated case. And if they can come to some areas of concession saying, yes, we agree you were the contractor hired. Yes, we agree that you were governed by these standards. Yes, we agree that the work was completed by this date. I think it shortens the process, but as far as getting them to agree on opinions, I think it's not a useful exercise.
Thanks. I just wanted to add something. One of the things that I've seen that hot tubbing helps with is when it's run by the tribunal, it really helps knowing that the presiding arbitrator has read very carefully the expert opinions, because they need to actually ask the questions first. And in those cases when there is no joint report requested, as Sasha said, it actually helps know what the actual disputed points are, and they normally are going to boil down to about 10%. 90% of the issues, there's going to be an agreement between the experts, and obviously they will have put their positions slightly differently depending on what their doctrinal and specific position in that particular on the particular facts of the case are, but there will be in the minds of the tribunal an agreement on 90% of the issues.
I'm surprised I don't see it more. Hot tubbing. I think I probably had it maybe 15-20% of cases where this happens, but and I've seen a number of variations on it as well. Sometimes they have hot tubbing with both experts there, but counsel are asking questions, but then there's some rules set around it now, whether that's helpful or not, and the tribunals listening and I think, but the point is about effectiveness. I fully agree. It needs to, not all cases are suited to it, but when it starts suited, at least you agree on the key areas of disagreement as a starting point, the respective positions, and then therefore at least the tribunal know where to focus their energy and focus of attention, and that can be an agreed. It can be helpful, but I've also seen areas where two experts are just saying completely polarized views, and I think you're going to get nowhere on that. But I think you need to pick the case, but the chair is important.
Hello, my name is Martin Pruski. I'm a quantum expert at Compass Lexon. I have a similar question that goes in a similar direction, and that would focus on joint expert statements, not reports that would be published subsequent to a hearing answering follow-up questions, but a brief statement that would be produced in the lead up to a hearing to help identify contentious topics and topics of lesser significance. So the tribunal can truly zoom in and know what are the relevant key issues they need to resolve at the hearing, and again, reconcile some of the lesser differences between experts. In my experience, it's something that's becoming more popular, but it's still not commonly used. And I was wondering, what's your take on it? Would you find it helpful to introduce that into the procedural order as a step in the lead up to the hearing, where you don't see particular value in that? Thank you.
Thank you. That's a great question. I recently had a case in England in front of, it was sitting in England in front of 3 English arbitrators. they seem to have a culture of asking for those joint reports. If I heard you correctly, you're a damages expert. It was a joint report by the damages experts and there was a commercial expert as well. Did I find it useful? I did. I think it actually helped a lot to get the questions that there's no disagreement about. However, I thought that they were very limited. They were it was pretty obvious that there was an agreement on those issues. They just put it in a clear language, and then there was a second column where they just rehashed their areas of disagreement. The part I didn't like about it was that it basically pretty much made the reports redundant. And they were extensive reports that had a lot of nuance that could be explored at cross-examination. And when I say redundant, I mean, I know the tribunal didn't read those. They didn't really care about those. And because the hearings are limited in time, they're not like your federal or litigation in court. There's no time to go through those, right? So it should be taken with a grain of salt. I think it can be done, but it should be done not in PO1, because you just don't know how the case is going to develop. It may well be the case that it's going to be well suited to the case, but I think this should be a decision that is taken when the record is in the end before closing. Yeah.
Hi, my name is Natalia Schlar. I'm an arbitration litigation associate at Wilder in Washington, D.C. And my question is about tribunal appointed experts, if any of you have had experience with tribunal appointed experts and how the cross-examination looked like in such case.
The answer is no. It's surprisingly rare. I've been practicing for over 30 years and I'm head of practice and I've never seen it.
I've had the privilege 3 times to be a tribunal appointed expert. What happens is that you end up getting lots of questions from both sides in terms of the cross-examination, but they tend to be in discrete areas like accounting. It won't be loss of profits, DCF. It's too much there because you have to rely on a lot of information, but it may be more like costs, so some cost approach in terms of what the numbers are and trying to get it to specific areas. Would I expect to see more? I mean, in these cases, parties have agreed to it. Obviously, they feel that it's a binary issue. Has to be a binary issue one way or the other way, so therefore they want to save costs. But I can imagine a lot of times counsel are not agreeing on that process, and therefore you have party-appointed experts. Now, the question is whether the tribunal should have their own tribunal-appointed expert, even though as party-appointed experts. I think from an efficiency and cost perspective, I can imagine it doesn't happen. Should it happen? I think maybe if you're going to write an award and you want it written in to the standard I would like to see, then I think you could probably do that.
I think that we are slowly running out of time, so I will take my privilege as a moderator to ask 2 final questions which are directed at all of you. So the first one is as follows. When we think of cross-examination, we usually think of leading questions, yes, because we want to lead the opposing side's experts somewhere, and we want to have our own conclusions to be confirmed. But does it ever make sense for you to ask open-ended questions during cross-examination? That's one thing. And going even further, would it ever make sense to resign from cross-examination of the opposing side's expert? What are your views on that?
If I may have the second question, would you ever not want to cross-examine the opposing counsel's expert? Yes. And let me give you an example of a real case. The purpose of the expert is to help the tribunal understand, to help them understand the complex issues, the technical issues. We had a case where the client was manufacturing technical industrial equipment, And the client, while they were trying to resolve the issue, hired their own consultant who wrote a very technical report. And I asked to hire an outside expert. They said, no, this is a full report. So I submitted that as the expert report. I then asked the client to have the person that wrote that report explain it to me so that I could understand what it said. And this was very early in my career, and I thought the other side did something brilliant, which is when we presented the expert, they said no questions. Because that didn't allow me to do a redirect, which meant the only exposure the tribunal had was this very complicated expert report, which I didn't understand until it was explained to me. The other side didn't do it, so essentially that expert's testimony disappeared. And in those kind of situations where you can control the evidence that comes from the other side, which is so complicated that it really requires explanation, but you're not going to get a chance to do it in the redirect. Why would you have him, the expert, explain it to cross-examination? And to prevent that, since that time, we always asked in procedural order number 1 for 30 minutes for the expert to explain their report in their own words. So that opens up the testimony, it allows the tribunal to ask the questions, and it requires the other side to cross-examine and clarifies the testimony.
I'm going to take on the first question. Do you ask open-ended questions? And if you look at the Bibles of that in the US, you will get a no. You don't do that ever. It's the ultimate no. The reality is in international arbitration that's really impossible. You can't go because you don't have the luxury of having taken depositions. You don't have broad discovery. You just don't have much to go based on. Do you do that indiscriminately? Of course not. You have to be very careful when you do it. One of the really okay times to do it is when you see an expert talking about satellite issues, which are taking away the focus from the actual main issues, because tribunals tend to focus on several important key problems, and everything else is kind of satellite stuff that they just and as Mr. Qureshi said, normally damages experts are in the end everybody's tired. You just ask an open-ended question. That's okay. They just go on and on about this particular satellite issue. The other time when it's okay is when you feel during the examination as it goes along, if you pay attention, a particular issue might not go well for the expert, and then you just want to let them keep digging into that hole. Just let them, how would you describe it in your own words? And they would go on a point that's already impeached, but you need to use your intuition on that. Because obviously, if you give them that option and they decide to pivot, then you get them on a contradiction, right? So it's either way you can't lose. Those are kind of the times when you should be okay with asking open-ended questions. The one I think the most I would be most averse to ask an open-ended question to a damages expert. They should be controlled as much as possible through the documents. But those two variations that I talked about apply equally with equal force to damages experts.
One final question from Mr. Nowacek.
I have a funny story to share if you allow me. Once I was chairing a very complicated arbitration. After examination of all the witnesses, we have examined the court-appointed expert. And as we all were very exhausted, after I ordered a lunch break. And after 1 hour, when we resumed, the parties come with the settlement agreement. Well, we were quite happy, and we entered the wording of the settlement agreement into the minutes. And while shaking hands of goodbye, I asked them, what happened? Why did you settle during the lunch break? Oh, say will not win this case. And the respondents' counsel said the same. The question is, can experts use their mediation skills? If not in the courtroom, then in the lunch break. Thank you.
So I think this was a rhetorical question and no answer is respecting. And with that funny story, I will conclude our panel. Thank you very much for your presentations and the discussion. Thank you for the questions and your participation. That will be all from my side. Thanks.